secure the doors. Members will please take their seats. Madam Clerk will please call the roll.
Mr. President.
All right. We'll keep the board open. It appears some of our colleagues took the way of the House and forgot where the State House is, so we're going to keep it open. And here, so hopefully they'll join. They'll join here any moment. Let's see. We are very, very pleased today to have Pastor Howard Travers from New Life Church in Salisbury, Maryland, guest of the distinguished senator from District 37. Members, please rise for the invocation.
Good morning, ladies and gentlemen. It is indeed a great honor and privilege to be again with you this morning. Would you join me in prayer? Almighty God, creator and sustainer, we give you thanks and praise for the gift of life and for this new day, which affords us new opportunities to begin again, to love more deeply and to serve more humbly. As we begin this day filled with both duties and challenges, we are encouraged knowing that your mercies and your grace are new every morning. As we prepare for the work ahead of us today, we look to you to guide our words and our actions. Let discernment over the difficult issues of our day be wise. Grant us strength to persevere in the ways that make for peace. Open our eyes that we might see the goodness in what we do here in this room. Open our ears that we may hear your voice and the will of all your people. Open our hearts that we might be compassionate in all that we do. Grant us, Lord, your wisdom that we may know the right decisions to make. Grant us your strength that we might resist that which draws us away from good and fair judgment. Strengthen our courage and our resolve to stand up for those issues we know to be just, for the gift of liberty and responsibility as leaders of this great nation. We are truly and eternally grateful. Protect and watch over all those who are today in harm's way. Console the families of those heroes, domestic and abroad, who sacrifice their lives that we might be free. And when evening comes and our duty here is done, may we know the deep contentment of work completed today, which honors our state, our great nation, and glorifies your name. Amen.
Chair recognizes the senator from the 37th District.
Thank you very much, Mr. President. Ladies and gentlemen, we are so pleased to have Pastor Howard with us. He is so very engaged in the community, and let me just share with you a couple of things that he does in addition to leading his flock there at the New Life Church. But he's been a bereavement care manager for Coastal Hospice, works with Witness International, oversees a transitional living ministry for individuals who are newly released from incarceration. He also partners and works with the Wicomico County Drug Court to support people in recovery. And he does quite a lot for the homeless and really is truly a minister and exemplifies what he believes in. So thank you so very much, Pastor Travers. We are so glad to have you here today. So I move that Pastor Travers' words prayer be journalized. Thank you, Mr. President.
Thank you so much, Senator, and thank you for recognizing such a leader in our community. And without objection, we'll certainly journalize the pastor's wonderful invocation this morning. All right, has everyone recorded their presence in the chamber? It appears so. The clerk will take the call. With 38 members in the chamber and a quorum being present, the Senate of Maryland is now in session. All right, we've got a busy day today, but let's do introductions first. Any introductions? We have a couple resolutions, but let's do introductions if we have any ahead of time. Any introductions? Appears not. Then let's go ahead and do our first resolution. Actually, that's a lie. I have an introduction. Apologies. We have some great guests today. One is the doctor of the day, Dr. Sarah Merritt, who does a doctor in pain management, former anesthesiologist. has two kids that are good friends with the Ferguson family friends, or the Ferguson's kids, and so we're so pleased to have her today. So Dr. Merritt, thank you for being here today. Chair recognizes the senator from the 37th District.
Thank you very much. Ladies and gentlemen, we also are delighted to have 4 of our pages in person, live and up front. So please welcome from Montgomery County District 15, Clarksburg High School, Nikita Balajapalli. Thank you, Nikita. Emily Modell from Hartford County District 35B, Sea Mountain Wright High School. Caroline Mulford, Anne Arundel County District 33, Archbishop Spalding High School. And Joshua Hirschfield, Howard County District 9A, Reservoir High School. Thank you all so much for being here with us. Have a wonderful day.
Thank you, Madam Co-Chair of the Protocol Committee. We are so pleased to have our pages here. Those gray jackets look excellent. Wore my gray suit just because we have 4 today. It's the most we've had. We're getting there. We're getting there. Getting back. All right. Let's go ahead and do our resolution. Chair recognizes the senator from the 38th District.
Thank you, Mr. President, Senate colleagues, my friends, visitors. On May 2nd, 2021, there was a horrific multi-vehicle accident on the Route 90 bridge in Ocean City that ejected a 2-year-old girl from her family's pickup truck into the cold water of the bay. Mr. Jonathan Bauer, who is the Chief Information Officer of Atlantic General Hospital, and his teenage daughter, Ava, were struck in their vehicle. And after making sure Ava was not hurt after being showered with glass, Jonathan ran to the truck, which was literally dangling over the bridge rail, saw the truck driver had freed himself, but he was pointing down to the water about 25 feet below. That was the moment when Jonathan Bauer, seeing the toddler face down in the water, jumped into the bay, swam to the little girl, who was unresponsive, lifted her up, patted her back until she coughed up water and opened her eyes. The toddler was airlifted to the hospital and released the next day. For 5 days, no one knew the unknown hero. Jonathan Bauer is a humble man who now has received well-deserved recognition at the local, state, and national levels for his heroic action in risking his life and saving the life of another. To paraphrase John 15:13, there is no greater love than to lay down one's life for another. Mr. President, our hearts are full as the Maryland State Senate recognizes and honors Jonathan Bauer with this Senate resolution.
The clerk will read the resolution.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to Jonathan Bauer in recognition of your courageous actions that resulted in the heroic rescue of a drowning toddler. The entire membership extends its best wishes on this memorable occasion and directs this resolution to be presented on the 16th day of February 2022.
Clerk will call the roll.
Mr. President.
Has everyone recorded their vote? If so, the clerk will take the call. Mr. Bauer, the Senate of Maryland unanimously thanks you for your heroic act and just a symbol of everything that is good in this state and what is good about humanity. Just thank you, thank you, thank you. We are so honored to be able to honor you today. Thank you. Excellent. Well, we're so pleased. And actually, as a quick aside, when the story happened, it was such an amazing story from the very beginning. That day that we heard that somebody had jumped in, I called Miss Walker, and who is a sleuth at figuring out where people are and finds ways to get in touch with people. And she was desperately trying to figure out who you were, and we couldn't figure it out for days and days because we wanted to make sure that you were able to be here today. So we're so pleased that this finally was able to happen, and just so thankful for you. So thank you so much. All right, we have another resolution today. If we have our guests are available, we have some folks in the gallery. Chair, I think we have the chair of the Baltimore City delegation doing the resolution today. Chair recognizes the chair of Baltimore City delegation.
Thank you, Mr. President. At this time, I'd just like to recognize the members of Mergenthaler Vocational Technical High School football team to acknowledge their great achievement. Under the direction of former Ravens Coach of the Week, Patrick Nixon, the Merville Mustangs won the 4A, 3A state championship title, bringing home the very first state title in the school's history. Achieving the rank of #1 in the division and #2 in Baltimore City League, these players have displayed a tremendous amount of courage, tenacity, bravery, and spirit. Might I add, in under especially tough circumstances. Winning this championship was an astounding triumph, not only because it was the school's first, but because it came shortly after the unfortunate and untimely passing of cherished teammate, wide receiver Elijah Quorum. Turning pain into purpose, these young men truly dedicated themselves to accomplishing such a great feature and did it in honor of Elijah. For the Mustangs, this was more than a game. This was more than a championship. This was more than a title. This was for Elijah, #7, and forever stands his memory. I'm extraordinarily proud of these young people and the efforts they have put forward, talented, full of heart, and coming out of the 43rd Legislative District. Coach Nixon and the Merville Mustangs are Baltimore's very own champions. Congratulations, team. You deserve all the kudos. And Mr. President, if I can just acknowledge one point. I was 30 years old when I first stepped on the Senate floor. And I look up in that gallery, and I look at these young men right here, and they've cut that in almost half. So I just say thank you also to you for that level of exposure, because it's very, very important. Colleagues.
Senator, can we ask the young men in the galleries to stand too so they can be recognized alongside?
Please. So joining Coach Nixon, you have Dante Fitzgerald, Sterling Thomas, Jacob Strong Foster, Corey Williams, DeAndre Ferguson, Derek Dunn, Mizell Brunson, Khalil Speaks, Assistant Coach Najee Brown, and Assistant Coach Tavon Smith. Colleagues, let's once again give a round of applause to the Merville Mustangs, our #1 champions.
Clerk will read the resolution.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the Mergenthaler Vocational Technical High School football team in recognition of winning your first 4A, 3A state championship, ranking #1 in your division and #2 in the Baltimore City League. We applaud your outstanding season and wish you many more. Congratulations.
Clerk will call the roll.
Mr. President.
Has everyone recorded their vote? And those who want to join, we'll do a picture up as we are calculating the vote here. Has everyone recorded? The clerk will take the call. Take the call. The Senate of Maryland unanimously celebrates Mergenthaler Voc Tech High School football team for the very first 4A, 3A state championship. Gentlemen and coaches, congratulations on your great work. Excellent. Thank you all so much. And we're going to make sure we win on that football field and win in the classroom too. We're going to do both of them. Great work, fellas. Great work. Glad you all were able to be here today. All right. Chair recognizes the senator from Howard and Baltimore counties.
Thank you, Mr. President. I'd like to ask the body to give a warm welcome to Marie Ezron, who's in the gallery. She is a fourth-year medical student, soon to be a physician, graduating from University of Maryland School of Medicine, interested in preventive medicine and family medicine, and also helping us in our office.
Wonderful.
Thank you.
Excellent. Thank you for being here. Welcome. Any other introductions, announcements? Yes, Chair recognizes Chair Judicial, Senator from Montgomery County.
Thank you, Mr. President. I have three special guests on the floor with me today. My niece, Catherine Robinson. She's a native of New York, born in New York, but is a 1L at University of Maryland Law School, your alma mater, Mr. President. Charlotte Hertzfield, next to her, also a 1L at the University of Maryland. And Matt Finberg, a constituent, a friend, former Obama official, State Department official, public servant, just great, all around great American and friend. So if you could all just extend a nice warm welcome to the three of them.
Welcome. Thanks for joining us today. Thank you all. Get ready for that civil procedure class. Yeah, it's a tough one. All right. Any other announcements, introductions? If not, so be considered the reading of the journal from the prior legislative day. We have some additional bills coming in. They needed some extra work. Clerk will read the bills.
Senate Bill 936, Senator Gallion, Public Utilities, Net Energy Metering, Eligibility Requirements, Rules.
Majority Leader moves so be considered the reading of the bills. They will be referred to the Standing Committee on Rules. We have some additional bond initiatives here. Number 23, clerk will read the bond initiatives.
Senator Benson, Mission of Charities New Facility. Senator McCray, Bear Community Outreach Center.
Majority Leader moves so be considered the reading of the bond initiatives. They will be referred to the subcommittee on capital. We've got second readers. Some of the work from yesterday. Let's go to Education, Health, and Environmental Affairs. This is report number 7. Clerk will read the first bill.
Senate Bill 15, Senator Jackson, Election Law, Campaign Finance Enforcement, favorable.
Chair recognizes the senator from Howard and Baltimore counties as the floor leader.
Thank you, Mr. President. Senate Bill 15 makes several changes to Title 13, which is campaign finance, and Title 14, disclosure by persons doing business, of the election law article into the Maryland Public Ethics Law. This is largely related to enforcement. These changes were requested by the Office of State Prosecutor and the State Board of Elections and include, number 1, changes to Title 13, increasing the statute of limitations on election law violations from 3 to 4 years. Number 2, prohibiting an individual from becoming a candidate for any public or party office in state or treasurer for a campaign finance entity for failing to pay a certain civil penalty for a certain period of time. Number 3, increasing the maximum civil penalty that can be imposed by the State Board of Elections for specified violations. There's also changes to Title 14 that are intended to be technical and cleanup to address intent that was missing in the original statute as drafted. This includes authorizing the Office of the State Prosecutor to issue a civil citation for filings for the contribution disclosure statement from persons doing businesses under Title 14. This is for persons or businesses that have government contracts over $200,000, so that's over $200,000 in government contracts with the state, and adding criminal penalties and fines. And secondly, broadening the applicability of record-keeping requirements and increasing penalties and enforcement authority under provisions requiring disclosure of contributions by persons providing compensation to lobbyists. It's a good government bill to help promote transparency and integrity in our elections and government contracting. There are no committee amendments. The vote was 10-1 in committee. Move the favorable adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. On the report, chair recognizes the senator from the 34th district.
Yeah, would the floor leader yield for a question?
Will appear so. Senator may proceed.
Thank you. One of the provisions changes the period of time in which this can be filed from 3 years to 4 years, right?
Yes.
And what was the purpose in doing that?
The purpose of doing that, it was really at the request of the Office of State Prosecutor. Some of these violations take some time for the State Board of Elections, which is first crack at this, to be able to investigate. And oftentimes they have a difficult time getting banking statements, financial disclosure statements, and the like, and it takes some time to do that. By the time they have concerns that rise to the level of bringing it to the attention of the state prosecutor, they're running up against the statute of limitations. And that's why this was brought forward by the State Board of Elections, as well as the State Prosecutor's Office, because they were concerned that they would not be able to follow up on these violations and investigate further because they were running up against the statute of limitations. And lining 3 years up with 4 helps line it up with the election year as well and gives them a little more time.
I'm sorry, 3 years up to 4, I couldn't hear your last, you trailed off. 3 years up to...
Changing it from 3 to 4 helps line it up with the election cycle, so it's more cyclical with the prior election, and then also gives them more time to complete their investigation.
So that's my concern, is that it lines it up with the election. So if there's a violation, if I screwed up something 4 years ago when I was running, and I didn't know it, but I screwed it up, and people now looking back as I'm running for office again, go back and look through it and say, hey, there was a screw up there. Now, on the eve of this election, they bring it up. I have no time, there is no time to respond. The only thing that comes out is there's a violation, and there's the headline, the violation. It just seems to me that we want to discourage that. I'm going to ask to just, Mr. President, I'm going to ask to lay it over for a personal amendment when we're done with this, because I would like to put that amendment in to look at taking it from 4 back to 3, because I just think we want to depoliticize this stuff. I'm no problem with the bill, that piece of it. So with that.
Senator, the layover would be out of order, but a special order for a day.
That would be fine. I'll order it today.
Senator moves to special order the bill for a day. Chair recognizes the floor leader.
Sure, if I could just answer his question real quick and then we have special order. The Office of State Prosecutor functions confidentially too. So if they're undergoing an investigation, they're not disclosing that to the public unless they actually have intent to bring.
No, but it can be filed. I mean, I look at it. It does get filed in court ultimately. So it just seems to me we ought to be, if you got issues, bring it up in year 3. Let's get it off the slate. You got a whole year to resolve it before the election, and then we go from there. But thank you very much.
We can work through this one. It's a good flag, good discussion. All right. Well, without objection, we will special order the bill to the appropriate time tomorrow. On the special order?
I actually had before we special ordered, I just had a quick question.
Let's just take it up afterward. If we need 2 days, we need 2 days. We're in no rush.
That's fine. It's just a quick question I would rather ask before we put it over to tomorrow, but that's fine.
We'll work through it. We'll have amendments. Thank you, Senator. All right. Clerk will read the next bill.
Senate Bill 19, Senator Lamb, Pharmacist, Administration of Maintenance, Injectable Medications, Treatment of Sexually Transmitted Infections, favorable.
Chair recognizes the sponsor of the bill as the floor leader.
Thank you, Mr. President. Senate Bill 19 alters the definition of maintenance injectable medication to include a medication that is administered by injection other than intravenously and treats a sexually transmitted infection and is not a vaccine. There are no committee amendments. Move the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. On the report, any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 19 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 108, Senator Ellis, Charles County Public Library, Imagination Library Program funding, favorable.
Chair recognizes the sponsor of the bill as the floor leader.
Thank you, Mr. President. Senate Bill 108 authorizes the Charles County Public Library to partner with an Imagination Library Program, which is a Dolly Parton Imagination Library Program, to provide free books to children up to 5 years of age from fiscal 2024 through 2033. The governor must annually include an appropriation to the library of $2.10. That's $2.10 for each child for each month that child is registered in the program. This bill takes effect July 1, 2022 and terminates June 30, 2032. There were no committee amendments and the fiscal impact is very minimal. Therefore, Mr. President, I ask for favorable adoption of the committee report.
All right, floor leader moves to the adoption of the favorable committee report. Love the Imagination program, but that Dolly Parton commercial wasn't a great one during the Super Bowl, you know. All right, on the report, any discussion? Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 108 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 325, Senator Lee, Student Data Privacy Protections, Digital Tools, and Student Data Privacy Council, favorable with 2 amendments.
Chair recognizes the senator from Baltimore and Howard counties as the floor leader.
Thank you, Mr. President. Senate Bill 325 reestablishes the Student Data Privacy Council, which terminated last year. This bill also modifies various definitions related to student data and requires each local Board of Education by July 1st of this year and annually thereafter to submit a list of specified digital tools to the Maryland State Department of Education. The department must publish an online database of the digital tools by September 1st of this year and annually thereafter. By December 1st of 2025, the Student Data Privacy Council must submit a report to the Governor and the General Assembly. The Council then terminates on September 30th, 2028. There are two committee amendments. The first committee amendment is technical, makes changes to the bill's title. Amendment number 2 strikes the provisions requiring the reporting of digital tools and the publication of the digital tool database. Move the adoption of the two committee amendments in the favorable committee report.
Floor leader moves for the adoption of the two committee amendments and the favorable committee report. On the amendments, chair recognizes the minority whip.
Thank you, Mr. President. I wonder if the floor leader would yield for a question.
Will the floor leader yield? Appears so. Senator may proceed.
I'm all for student data privacy, so I was trying to look at what we're adding into this that wasn't present before. I know you said it expired and we're reestablishing the council, which is fine. I was trying to look at the amendment and just see, could you answer kind of what adjustments were made or what additional?
So the bill, I think, really just focuses on extending the term of the Student Data Privacy Council, as well as additional reporting.
Why, if I might ask another question, why did there may have has opposition letter in the committee testimony? Were there concerns assuaged by the hearing and by the amendments, or?
I think their concerns were mainly regarding reporting, but this is reporting that had to be done before already. And so there are information that needs to be collected and recorded as part of mandated collection and compilation. And it also includes information on, I think they did add information on disciplinary information, online behavior, or usage of applications, any unique identifiers to these students. All of that information is new, but I think it's new reflective of some of the digital tools that are now out there that students are using.
Is the reporting to make sure that schools are not aware of all these things on the children's digital habits, or is it so that like vendors or outside entities are not aware?
The outside entities are aware. They need to report to the council, and the council, or they need to report to the local board rather. The local boards then report that to the council, so that it's all compiled information there. And it's really just making sure that there's proper disclosure and making sure that these outside companies that are engaged in businesses or contracts with this local boards of education, not the election, boards of education,
yeah, sure,
and the school systems are not doing anything with that information, the personal information, for example, students, selling them to advertisers or other vendors and the like. It's making sure that the privacy of the students is held utmost.
Okay. Thank you. Mr. President, I just wonder if I could lay this bill over for a day. I just want to check one item, and I think it's a good thing to move forward on. I just want to check something. So
Senator's motion is in order. The bill and the amendments will lay over under the rule. Clerk, read the next bill. Oh, that's right. Let's go to report number 8. We'll stay with EHE. Clerk will read the first bill on report 8.
Senate Bill 67, Senator Kagan, Animal Welfare, Deploying Cats, Prohibited Acts, favorable with 2 amendments.
We have gotten some emails on this one, let me tell you. Chair recognizes the bill sponsor as the floor leader.
Marylanders love their cats. Thank you, Mr. President. Before I start, can I just say I want to share something? Do you all know that our Office of Information System checks every mic every day? And I just think we ought to appreciate their diligence. It's a lot of invisible stuff that we don't see. And they noticed that my microphone wasn't working this morning. And so while there's some people who think that might have been a benefit to the body, it is working now thanks to our diligent tech people. So I just think we ought to recognize
Fair enough.
and
No,
appreciate them.
our tech team is doing amazing, amazing work. These last 2 years, they have been beyond overloaded. So appreciate that. Yes, Senator, please proceed.
Thank you, Mr. President. Senate Bill 67 is about our furry critters, our little kittens, our cats, and protecting them from being mutilated. Declawing a cat is what we normally call it, but it's actually deknuckling. It's not just taking off and doing a little manicure and trimming their nails. It's actually removing the first knuckle of their paws, of the first 10 on their front, and as well as generally the 8 of their rear paws. This causes enormous pain and lifelong challenges for the cat. Now, a lot of cat moms and dads decide that this is going to be good to protect grandma's sofa because the cat, you know, is sharpening its claws or maybe scratching, you know, the kids or the parents or something. The problem is that that the cat, which is now disfigured and now has no ability to defend itself, number one, bites rather than scratches, which is much more serious, and second, finds using the litter box a lot more uncomfortable because now there's like a cavity where there used to be a knuckle or a bone. So instead of using their litter box, they decide to use grandma's couch as their litter box. And what happens then is that the cats, obviously that's not great behavior, and the cats end up disproportionately being brought to shelters to be euthanized. So this is a simple bill to have us join over 40 countries, major cities, the state of New York and others to make sure that we can protect our kitties. There is an exemption if there's a real important reason to declaw or deknuckle, as people are now calling it, to do that. Let's say there's a tumor in the paw. Of course, we want our veterinarians to protect our cats, but in general, this would outlaw the deknuckling. And I don't know whether you all will be able to see this, but I want you to have the
Senator,
graphic.
that'd be out of order. Out of order.
Okay, no props. Okay, let me just say then that there are 2 amendments. The first one is technical, and the second one simply gives some flexibility to the veterinary board so that if someone does this, they don't automatically lose their license or anything. They would have a hearing, they would have a conversation, and there can be penalties, but it authorizes a little more flexibility for a veterinarian. So with that, Mr. President, with the amendments, I think this is a perfect bill, and move the bill, Senate Bill 67, favorable with 2 amendments.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Chair recognizes Senator from District 3 on the amendments.
Thank you.
Does the Senator have questions for the floor leader?
I have a question for the floor leader. Thank you. Yes.
Senator may proceed.
Just as a quick aside, a neighbor of mine declawed their cat, and it was on a leash on the balcony and fell off and hung itself. So that's another side effect. But I know pulling them out is rough and all. Wouldn't lasering be better?
Thank you for the question, Senator. So there are veterinarians who say, oh, but I laser them. So I'm going to give kind of a gross analogy. If you're decapitating someone, does it matter whether you use an axe, a machete, or a laser? You still have no head. So I think that lasering, while it sounds high-tech and it may sound nicer for the cat, I assure you that it still results in limping, lifelong pain, and problems using a litter box and defending itself. So lasering is not a good option, but thank you. Still, about 20 to 25% of cats are declawed or deknuckled, and so we want to put an end to that.
Chair recognizes the Senator from District 7 on the amendments.
Thank you. Yield for questions?
Of course.
Senator may proceed.
All right. So listening to your story about Grandma and her little kitty and the fact that, you know, it was scratching her couch, so she was upset. So she takes the kitten, has it declawed. Now you're saying that it's having a problem in the litter box, so it's using her couch. So she gets rid of it. What's Grandma going to do if this cat's still, if she doesn't go that option, and now this cat's shredding her sofa, shredding her other furniture? What options does she have?
That's a great question. Thank you. There are several options. There's everything from behavioral care. There can be, you know, you train the cat, you offer alternatives. There are scratching posts, there are games, and there's also nail caps that are kind of hip looking actually, and they can be put on. They last for quite a while, and that makes the claws, it still keeps the claws on, but it protects the furniture.
Have you ever really had an adult cat to try to train? I mean, cats are cats, man. They are tough. They're not a dog. They have their own mind. They'll do their own thing. and I just see this bill. I understand where you're coming from it.
The most important, the easiest option, Senator, is to trim their nails regularly. And that was, I assure you, I had my share of cat scratches. But by keeping their nails trimmed, they're not sharp, they don't injure, they don't damage the furniture.
All right. Mr. President, I've actually gotten, as you said, this bill's brought in a lot of emails. I've gotten both sides. I had one vet who contacted me who was totally for this bill, and I've got several that are saying no. They only use it in certain circumstances. But I'm also getting other emails and texts as I'm sitting here. Can I lay the bill and amendments over so I can kind of do some more research for tomorrow?
Senator, the motion's in order. The bill and the amendment bill and the amendments will lie over under the rule. Clerk, read the next bill.
Senate Bill 81, Senator Feldman, Charter Counties Enforcement of Local Building Performance Laws, Building Energy Performance Standards Act of 2022, favorable with one amendment.
Chair recognizes the chair of the committee as the floor leader.
Thank you, Mr. President. This is enabling legislation. Senate Bill 81 authorizes charter counties to impose civil fines up to $10 per square foot of gross floor area to enforce local building energy performance laws. A charter county must consider the assessed value of the property in determining the civil fine imposed under the bill. There's one amendment. The amendment exempts new construction, anything built within 3 years before the penalty would be imposed, from the new civil penalty provisions.
Senator, just one moment. It's getting a little loud. Please, can we take side conversations outside of the chamber? Thank you very much. Senator may proceed.
Yeah, Mr. President, we've had at least one county, and this is supported by NACO, where they've had difficulty enforcing local codes because right now the fine is up to $1,000. And some businesses just make it a cost of doing business, and they want to be able to enforce their performance building codes. So again, it's authorizing, it enables Charter County to proceed with this. As I said, there's one amendment, I think requested by the builders, to exempt anything within 3 years of the penalty. Move adoption of the one committee amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. Question on the amendment? All in favor? Any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 81 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 90, Senator West, Department of the Environment, Supplemental Environmental Projects Database, favorable.
Chair recognizes the senator from the 33rd District as the floor leader.
Thank you, Mr. President. Senate Bill 90 requires the Maryland Department of the Environment to create and maintain a database of supplemental environmental projects that the department may consider for implementation as part of the settlement of an enforcement action. In creating and maintaining the database, MDE must solicit input from communities in the state that are overburdened, underserved, or otherwise disadvantaged by environmental stressors. No committee amendments. Move the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Question is on the report. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 90 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 296, Senator Gallion, Land Use, Agritourism, Definition, favorable with one amendment.
Chair recognizes the senator from Harford County as the floor leader.
Thank you, Mr. President. A very popular thing for farmers to supplement their incomes nowadays are through ag tourism. Different things included in that would be hay rides, pumpkin picking, farm tours, and the such. So what this bill simply does is add overnight farm stays to the definition of agritourism. We have one amendment, and that is a co-sponsor amendment. It passed unanimously in committee. I'd like to move the amendment and for adoption of the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now is the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 296 is hereby ordered printed for third reader. That does it for that calendar. Excuse me. We have one more for Education, Health, and Environmental Affairs. Clerk will read the bill, calendar number 9.
Senate Bill 120, Senator Lamb, acupuncture licensure requirements favorable with one amendment.
Chair recognizes the bill sponsors, the floor leader.
Thank you, Mr. President. Senate Bill 120 alters one of the education and training pathways to qualify as a licensed acupuncturist for applicants licensed by the State Acupuncture Board beginning on May 31st, 2026. There's one committee amendment. The amendment requires beginning on or after June 1st, 2026, that all applicants must possess a master's level degree and have a passing score in a national certifying exam. The amendment also repeals the requirement for applicants to possess a diplomate. Move the adoption of the one committee amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report on the amendment. Any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 120 is hereby ordered printed for third reader. All right, let's go to judicial proceedings. This is report number 4. We'll start with the clerk reading the first bill.
Senate Bill 13, Senator McCray, Vehicle Theft Prevention Fund, allocation of grants favorable with one amendment.
Chair recognizes the senator from the 23rd District as the floor leader.
Thank you, Mr. President. As amended, this bill requires the Vehicle Theft Prevention Council and the Department of State Police, to the extent practical, to consider allocating grants from the Vehicle Theft Prevention Fund on a pro rata basis, determined by the total number of vehicles stolen in each subdivision of the state divided by the total number of vehicles stolen in the state, rather than requiring, to the extent practical, allocation by the total number of vehicles registered in each subdivision divided by the total number of vehicles registered in the state. There's one committee amendment. The amendment strikes the mandatory formula language in the bill and instead requires the council to consider allocating grant funds as specified. I move the adoption of the amendments in a favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report on the amendment. Any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 13 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 17, Senator West, child custody, cases involving child abuse or domestic violence, training for judges, favorable with one amendment.
Chair recognizes the bill sponsors, the floor leader.
Thank you, Mr. President. Senate Bill 17 is the result of a number of terribly tragic situations in which a court awarded custody of a child to an abusive parent, and the child was thereafter either sexually abused or killed. This bill requires the judiciary, in consultation with domestic violence and child abuse organizations, to develop a training program for judges presiding over child custody cases involving child abuse or domestic violence. The bill establishes minimum training requirements for judges presiding over child custody cases, including child abuse or domestic violence. There's one committee amendment. The amendment defines child abuse and domestic violence. The amendment reduces the list of topics that must be included in the training program, and the amendment alters the qualifications for an individual or organization providing training under the bill. I move the adoption of the amendment and the favorable committee report.
Floor leader moves for the adoption of the one committee amendment and the favorable committee report on the amendment. Any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now on the favorable committee report is amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 17 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 71, Senator Kramer, hate crimes, civil remedy, favorable with two amendments.
Chair recognizes the senator from the 44th District as the floor leader.
Thank you very much, Mr. President. Senate Bill 71 is a bill that authorizes a person who is the victim of a violation of the state's hate crime laws to bring a civil action against the person or persons who committed the act and authorizes the court to award a variety of specified remedies. There are two amendments. Amendment 1 increases the number of sponsors. Amendment number 2 specifies that a person who brings a civil action under the bill must have suffered harm from the act of a kind different from the harm suffered by a person within the class protected under this subtitle who is a victim of that act. The vote of the committee was unanimous. Mr. President, I move the adoption of the amendments in the favorable committee report.
Floor leader moves for the adoption of the two committee amendments in the favorable committee report. First on the amendments. Any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The two committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 71 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 97, Senator Vital, Clerks of the Circuit Courts, bonds, licenses, oaths, and commissions, favorable with two amendments.
Chair recognizes Chair of the Committee as the floor leader.
Thank you, Mr. President. This bill amends numerous provisions under the Courts and Judicial Proceedings article relating to the administrative duties of a clerk of a circuit court. The bill also repeals certain penalties for non-performance of certain duties. So essentially what happens when a clerk gets sworn in, they apply for licenses, blank licenses that they need. If they kind of overestimate or underestimate what they need, there's a penalty if they don't coordinate with the comptroller's office. So there are two amendments. One is technical. Amendment number 2 strikes changes relating to the Civil Commission, relating to the Oaths and Taxes Commission of the Courts article, and those 3 sections remain in current law. I'd move for the adoption of the two committee amendments in the favorable committee report.
Floor leader moves for the adoption of the two committee amendments in the favorable committee report. On the amendments, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The two committee amendments are adopted. Question now on the the favorable report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 97 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 125, Senator Vital, revival of non-stock and religious corporations, favorable.
Chair recognizes the Chair of the Committee as the floor leader.
Thank you, Mr. President. This bill creates an exemption to the requirement that all past due annual reports be filed by a corporation when filing articles of revival with SSTAT. Instead of filing, if they file online, they only have to go back 7 years. There are no committee amendments. It passed the committee unanimously. It asked for the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? If not, on the report, all in favor say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 125 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 261, Senator West, corporations and associations, limited liability companies and partnerships, operating agreements and partnership agreements, favorable with one amendment.
Chair recognizes the bill sponsor as the floor leader.
Thank you, Mr. President. This bill specifies that provisions in limited liability company operating agreements and partnership agreements providing for transfers of membership interests or partnership interests in partnerships or LLCs upon the death of a partner or a member are effective according to the agreement and are not to be considered testamentary and thus are not subject to the requirements for the execution of wills. The bill provides to all operating agreements and partnership agreements in effect on the bill's effective date. There is there's one technical amendment. The vote in the committee was unanimous. I hereby move the adoption of the amendment and the favorable committee report.
Floor leader moves for the adoption of the one amendment in the favorable committee report. It's an interesting issue. I bet there were some tricky situations that came out of that. On the amendment, any discussion? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The one committee amendment is adopted. Question now on the favorable committee report is amended. Any discussion? Yes, Chair recognizes the senator from Charles County on the report.
On the report. Thank you, Mr. President. Question for the floor leader.
The floor leader yields.
Surely.
Senator may proceed.
Thank you, sir. So this bill authorizes transfer of partnership share. Does it require the unanimous vote of all the partners to do that, or is it automatic?
What happens is LLC operating agreements and partnership agreements almost invariably contain a provision dealing with the fact that at some point along the way, a member or a partner is going to die. And the agreements provide typically for the interest of the dead partner to be valued and then enable the remaining partners or LLC members to purchase that interest. So that's in almost all partnership agreements and LLC operating agreements. And they're just signed by everybody who's a partner or a member of the LLC. The Court of Special Appeals last summer issued a decision that because they dealt with an interest that was going to pass after the death of a partner or an LLC member, the partnership agreement or the LLC operating agreement had to be executed in the same way that a will is executed. We got tens of thousands of these agreements across the state. Virtually none of them were executed like a will. And therefore, if that decision stands, it's going to be chaotic because so many of these operating agreements and partnership agreements will be nullified because they were not executed like a will. So this merely says that they don't have to be executed as a will is executed with notary public and witnesses and all that kind of thing.
Okay, good. Thank you for that explanation.
Sure.
Thank you, Senator. It's helpful. It's interesting. I'm sure there were some interesting cases related to this. All right, on the report, any further discussion? If not, all in favor of the report, say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 261 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 341, Caroline County Senators, Caroline County State's Attorney and Sheriff's salaries favorable.
Chair recognizes the Senator from St. Mary's as the floor leader.
Thank you, Mr. President. This bill alters the annual salary of the state's attorney and the sheriff for Caroline County by establishing that the salary of the state's attorney is equal to 85% of the salary of a district court judge, and the salary of the sheriff is equal to 85% of the salary of the state's attorney. This is pursuant to constitutional requirements. The salary takes effect at the beginning of the next term of office. There were no committee amendments. Passed the committee unanimously. I move for the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. On the report, any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 341 is hereby ordered printed for third reader. Ladies and gentlemen, Senator from District 14, we have a guest in the gallery who is joining us, and I saw him pulling out some measuring tape. It looked like measuring the drapes. We have the Majority Leader of the House of Delegates joining us here from District 14. Welcome, welcome. Taking tips on you know.
Mr. President?
Yes, Chair recognizes the Senator from the 14th District.
I just am so thankful that the Majority Leader is here and see us in action. And Mr. Majority Leader, we've got about 150 bills over there, so just keep an eye on it. But with that, no, it's always great to see you, my teammate. Thank you.
Great partnership. Thank you, Senator. All right, we got one more. We've got a special order. Clerk will read the bill.
Senate Bill 30, Senator Carter, Courts Jury Service Disqualification. Question is on the adoption of the amendment offered from the floor by Senator Reedy.
All right, Senators, this is, the bill is on second reader still. We have an amendment. This is the Minority Whip's amendment. The amendment should be on the floor system. Any discussion on the amendment? Chair recognizes the Minority Whip.
Thank you, Mr. President. To reiterate for the body, this amendment this bill, just so we're clear, this bill eliminates the idea that someone who has a felony conviction can't serve on jury. So it's going to allow anybody with any kind of felony conviction to be selected for and serve on a jury. I think that's a mistake, and I think that's the wrong policy. But what this amendment sought to do was simply to, at the very least, say, let's have an exception for those who have committed crimes that deal with directly deceiving, lying to the court system, or interfering in the processes of the court system in their past. Because as I reiterated earlier, someone robs a store 25 years ago. I don't agree if they had a felony conviction for that. I don't really think they should serve on a jury, but I can understand, at least the argument is, hey, they've changed, whatever. Someone has deliberately done the following: committed perjury, participated in witness intimidation, jury intimidation, or a number of different types of fraud, including counterfeiting and elder abuse types of fraud. I don't believe that person should be serving on a jury or even be in the queue to get selected for a jury. So that's what the amendment does, Mr. President, and I think it's a nice safeguard on this bill because it seems like it probably is moving forward, but I think it would be a great safeguard just to be sure we keep those kind of people should stay off of juries. So I move the amendment, and I will ask for a roll call.
Thank you, Senator. And Chair recognizes the floor leader on the amendment.
Thank you, Mr. President. Members of the body, I'd urge you to resist this unnecessary amendment. Respectfully, I think that we get into a slippery slope and a dangerous proposition when we choose to stand instead of the court. This should be a blanket release of the prohibition of people that have certain convictions from being able to serve on a jury. We've decided years ago that restoring the right to vote was important and necessary to reintegrate people that have stumbled back into society and give them full citizenship. This is simply just another step in that direction. To make a decision that someone's conviction, the nature of the conviction is a reason, is a slippery slope, because who are we to determine that that person can or cannot be fair? Who are we to determine that the person that committed the robbery is better to serve? That's something that best left up to the courts and the voir dire process. And I would simply just reiterate that all of these cases, this bill could not necessarily result in all of these people being able to now serve on a jury. It just makes them eligible to be serving on a jury. And they still have to go through the process of voir dire, and there is no restriction in Maryland for excluding a juror for cause. And so I would submit to you that if there were cause because of the nature of one of these convictions, they absolutely would be excluded. So for those reasons, I suggest that we pass this bill just as we did last year, with some bipartisan support, straight as it is now, without this amendment. Thank you.
Chair recognizes the senator from District 10 on the amendment.
My concern also is that if people have done their time, if they have been rehabilitated, we put them into jail or you took them through corrections, and they, as I recall when the bill was on the floor, there's a certain amount of time that's got to pass for all of that to happen. Do we believe in corrections or do we not? In each case, if the person is now able to do everything else in society, we ought not, out of hand, when we are not in that courtroom and when we are not making the decision on a particular case, just to say to people that you are never going to be a full citizen again. This is really a basic citizenship right. The courts are still there to uphold the law and to make sure that that any particular court case is handled in a fair and impartial manner. If they agree in a particular courtroom that you are eligible to serve, that you are not a pariah forever and ever and ever, we ought not. I think we really want to hold up to people who have been in corrections the possibility that they can do good, that they can be applauded for doing good, that we can respect that corrections work. So else why go through all of that we do in order to have a correction system? Thank you.
Thank you. Senator Chair recognizes the chair of the committee on the amendment.
Thank you, Mr. President. I wonder if I could ask the maker of the amendment a question.
Will the maker of the amendment yield?
Absolutely.
Senator may proceed.
Thank you. Just a clarifying question. Does this still include Title 8 in this iteration of your amendment?
It does.
Okay. So just first, if I could speak on the amendment, Mr. President?
On the amendment, Senator may proceed.
This is part of a problematic, they're problematic for many reasons, but this part, there are a couple crimes that are listed here. Title 8 includes some crimes that are punishable in less than a year. So things like unauthorized transfer of a ticket, which carries a penalty of like 90 days. Things like failing to pay court fines or court keys or passing a bad check. Things that are incarcerable for 60 days or less. You're excluding people like that, so it's overly broad in that sense. But in the larger scope, speaking on the amendment again, what's most important, obviously we've moved as a body, as the senator from Baltimore County said, we've moved to expand folks that have been, to re-enfranchise folks that have been formerly incarcerated, even if they're under judicial supervision. We've done that. This is critical, and I'll just speak a little bit to the voir dire process, because it's the most important, as the senator from Baltimore City spoke to. The voir dire process works. The court system works, and it's important to understand both the civil and the criminal aspect of the voir dire process. So generally, each party would get 4 preemptory challenges. A juror can be knocked off for a cause 4 times, generally speaking. But cases involving life imprisonment, the defendant gets 20 opportunities to make that strike, and the state has 10. For cases involving imprisonment for 20 years or more, but less than life, the defendant has 10 opportunities to do that, to strike someone for cause off of the jury, and the state has 5. For civil, generally each party gets 4. So the process works. There is a vetting process in place to keep people off. All that information is available to the court to make sound and wise decisions, and so I urge the body to reject the amendment.
Let's hear from a senator who has not yet. Do any senators who have not yet spoken wish to speak? If not, we'll go back to the maker of the amendment.
Thank you, Mr. President, and those are all very interesting comments. I actually have a question for the sponsor of the bill, the floor leader, if I might.
Well, the sponsor, it appears so. Senator may proceed.
You mentioned something when we talked about the voir dire process, which I've practiced saying that the last few days to be sure I say voir dire right, because that's a new term for me as a non-lawyer, but it's an important process, a very important process, which you all have pointed out well, you and the chair on the floor. You said that someone can still be struck for cause. So this bill does not eliminate the ability for someone to be struck for cause for a potential criminal record.
That's correct.
Okay, can you be struck for cause before a preemptory challenge?
Yes.
So this bill does not impact that at all?
No.
Okay. Mr. President, the chairman's brought up an excellent, thank you. The chairman's brought up a point about Title VIII that I think is a fair one, although there are things in Title VIII that I think are not good and should be included in my amendment, but when we put Title VIII in it does include things like writing a bad check. And I respect that point of view. And so even though I don't like this bill at all, what I'd like to do is actually withdraw my amendment.
Senators move to withdraw the amendment with a substitute amendment, I suspect.
And offer a substitute amendment.
The amendment has been withdrawn.
I don't want to.
Senator has an amendment. Pages will collect the senator's amendment.
And I'll keep a copy of it just to be sure. And I'm going to say this, and it's going to sound like a joke, but I'm very serious because this is a serious issue. I'm not going to let people off the hook for voting against this amendment. This amendment is an important amendment.
But Senator, hold on. Let's give us 1 second.
I'll let it
let's just make sure. We want to make sure that we have the right, everything correct. Does everyone have the amendment? Let's see. 2-5. Appears this is correct. All right, Senator may proceed on the amendment.
Thank you, Mr. President. And I do appreciate the dialogue I've had with the chair and the sponsor on this issue, though we have some sharp disagreement. This amendment now simply says that we're going to make sure that this bill, it's an exception in this bill. And by the way, when we talk about substituting our judgment for the court, before this bill, you had a felony, you're out. So we're saying now you're not out at all, there's nobody out. So it's just hardly substituting our judgment. We're substituting our judgment in this body for a system that's been in place for a long, long time. So I think it's very important that we make sure that people who've engaged in jury intimidation, witness intimidation, or perjury are still limited and not able to be a part of a jury pool and a jury process. I think that is a very fair amendment. And I would move the amendment, Mr. President, ask for a roll call. And I know we've had the debate sort of already, but I appreciate the opportunity to say this is an important amendment. Let's be sure we keep folks that we know have actively deceived the court system or attempted to interfere in the process. They should stay out. So I move the amendment, Mr. President.
All right, Senator moves the amendment. Chair recognizes the floor leader on the amendment.
Thank you, Mr. President. Members of the body, I'd first of all just reiterate what we already know. This bill's been special ordered like 3 times, and we passed the bill without this amendment last year. Not saying that we have to do what we've done before, but the amendment might sound like it's not unreasonable on its face. I would simply note a couple of things that are critically to think of in the process. Again, there is no restriction on a strike for cause. So, should a person come before the court with one of these priors in their background, it would be disclosed. Throughout the voir dire process, jurors are required to swear under oath, and so a judge, the litigators have every option to strike these people for cause, and if for some reason that doesn't work, it can be done through a peremptory challenge. So I just don't think this amendment is necessary. And finally, I'll say that even where some states continue to exclude an offense or two, they don't ever exclude it for life. Even when we restored voter rights for ex-felons, and we restricted for a couple of things, we said give it more time. We didn't say for life you can't vote. We said give it more time. And so for all of those reasons, I would say please resist this amendment, pass this bill as this committee decided it's in its best shape, as we did last year, and let's take pleasure in the fact that we've done something good for our democracy and to reintegrate people into society and give them full citizenship. Thank you.
All right, on the amendment, let's go ahead to the minority leader on the amendment.
Thank you, Mr. President. I rise in support of the amendment. I think it's a balanced approach. And when I was sitting here, I started thinking, what do we do as a body in regards to this type of policy? Are we new grounds? It was brought up about felons and voting. And I started thinking about felons not being able to have guns. There are certain privileges we do not allow certain people who are convicted of certain crimes. Those with sex offense, there are certain things they cannot do. And I went back just on the floor here and looked at the voting rights. And we said we wanted to give voting rights back to those who had committed a felony. And when I pulled up the bill, it says an individual is not qualified to be registered voter if the individual, and then we amended that. But I went on further, it said, but they can't if they've been convicted of buying or selling votes. That's exactly what we're doing here. We're saying there are certain things that are so closely related to the activity or the privilege that we want to grant that we say, under those circumstances, we're going to limit that. That's what we've done as a body in the past. I think we should do it here. I think it's reasonable and balanced. Thank you.
Thank you, Senator. All right, Chair recognizes the Senator from the 17th District on the amendment.
Thank you, Mr. President. Would the floor leader yield, please?
The floor leader yield. Pierce-O, Senator may proceed.
Thank you. Just a couple of quick questions. First off, did the committee consider this issue in its deliberations?
So we didn't consider this specific amendment, but we certainly considered what we've passed we looked at other states, and we looked at what we've passed in the past when it comes to the restoration of rights, when it comes to voting, which this is most akin to.
Are there other states that have disqualified for exactly these reasons?
So I'm not aware of any other states that disqualify for these exact reasons. Different states do different things. I'll just give you an overview. Some states say, you know what? When someone's been the only exclusion is they're actually incarcerated, and so we don't even exclude them. We just excuse them from service because they're incarcerated, so we excuse them, they can't do it. There are 2 states that exclude for certain offenses. One state that I'm aware of excludes for murder. One state excludes for sex offense and murder. Most states say we are only excluding for the time period of the sentence, but even if we exclude for any specific offense, we say a certain period of time. So like we did with the voting. Like, you're released, you can vote. But in an extreme low minority of cases, like if you have been convicted of voter fraud, you just have to wait a little bit longer. Like, you can't do it immediately. You got to finish your parole and probation. So that's kind of like the overview of what most states do. And it's why I really think we should not exclude for any of these things, because the court can certainly make those determinations.
Just a couple more quick questions. How common are these violations?
Oh, they're extreme. I mean, I don't know, but they're extremely
perjury,
rare.
witness intimidation, and juror intimidation.
Right. I think that they are extremely rare because they're rarely prosecuted or convicted.
Okay, and last question. You said that folks can use their voir dire, which makes sense. but you also indicated, and the chair indicated, that there are limitations to the number of voir dire. So I was just wondering, are they kind of using up part of their rare supply?
So I would say no, because there's no limitation at all, again, for cause. So certainly an attorney could say to the court, this person's been prior convicted of juror intimidation. I would like to strike for cause, and the court will strike for cause. The question is, the limitation is on peremptory challenges where you can say, I just don't like the looks of this person. You have a limitation only for those strikes.
That was really helpful. Thank you, Senator.
Thank you.
Chair recognizes the chair of the committee.
Thank you, Mr. President, and I'd just like to speak on the amendment really quickly. So I actually, I agree with the whole notion of restorative justice, and that's why I supported reenfranchisement, even for folks that are just coming out. But here, look, you make a good point on the witness intimidation and the jury intimidation because it's germane to the actual activity that's going on. Perjury is way too broad because I think it was 3 or 4 years ago, we actually, remember there was a bill before us that we allowed people that have been convicted of perjury to participate in the process again because perjury is a very broad crime. You could signing a contract under oath and not doing it properly. Those things, it's a broad scope. It's not just perjury in terms of going before a judge, swearing, and just telling a lie. It encompasses a lot of activities, so that's too broad. So might I make a recommendation to the senator? If you stripped out perjury, I could see supporting this amendment because it's germane to the underlying activity.
All right. On the amendment,
Mr. President?
Chair recognizes the maker of the amendment.
I'd be happy to special order for a day so that we can discuss that.
On the amendment, it seems like there's an ongoing conversation. Special order would be in order. In
Yes,
response from the chair or from the chair of the committee.
Happy to accommodate if there are no additional forthcoming amendments.
Right. Okay. Well, look. Let's not negotiate this here. I think there's some real questions here. We have a lot of time tomorrow too. We got a free day. A very open day tomorrow. If there are no objections to the special order, we will special order the amendment and the bill to the appropriate time tomorrow.
Thank you,
All
Mr.
right?
President.
So the desk is clear. The desk is clear. So first, before we do committee announcements, I do want to thank the chairs, committee staff, all members, our incredible legislative security unit. Yesterday was the first day back, and we had a big day. The climate bill had a lot of folks there. There was concern about people showing up, whether or not people would show up. I think that one bill went for 4.5 hours, which is a sign that I think people are really want to testify on their issues that matter to them. So just want to thank all of the hard work that went into it. We still got a long week. There are going to be bumps in the road. There are going to be issues that arise. And so please don't hesitate to flag those for us so we can make sure that we take care of them. But just want to thank all the folks that helped navigate our first day back in 2 years yesterday, and let's keep it going. So with that, let's recognize the Chair of Finance for committee announcements.
Finance will meet at 1 for committee hearings, and we have 8 bills to hear.
All right. Thank you, Madam Chair. Chair recognizes the Chair of Education, Health, and Environmental Affairs.
Mr. President, I'd like to echo what you just spoke to. You know, we weren't sure if yesterday we would start with a whimper or a bang, and as you mentioned, we were in for over 7 hours yesterday, had lots of witnesses, and you know, the senator from Harford County said our security, our committee staff, it was seamless. We had people coming and going and having panels come in and people in the outer hallway, and it worked amazingly so. And in addition, our committee at 8 or 8:30, whenever we ended, were all present and accounted for, all 11, and engaged. So I think it speaks to the staff of keeping this running well, and obviously I want to thank my committee. That being said, we'll meet at 1 o'clock. Today is an education day. I think we have 8 or 10 bills. We'll start at 1 o'clock.
9 hours tonight. Thank you, Mr. Chairman. Chair recognizes the Chair of Budget and Tax.
Thank you, Mr. President. Today at 1 o'clock, we have 17 bills, followed by a voting session.
Busy day, busy day. Thank you, Mr. Chairman. Chair recognizes the Chair of Judicial Proceedings.
Thank you, Mr. President. Today we will meet at 1 p.m. for bill hearings. Today is our gun day, so we have a long, long day and night ahead of us.
JPR is in it now. It was EHE yesterday. B&T and JPR have it today, so we'll keep moving along. All right, any other standing committee announcements? Select committees, delegations, any other announcements before we adjourn? If not, let's do a quorum call before we adjourn.
Mr. President,
Has everyone recorded their presence in the chamber? If so, clerk will take the call. With 46 members in the chamber and a quorum being present, Senate of Maryland remains in session. Chair recognizes the majority leader.
Thank you, Mr. President. I move the Senate of Maryland stand adjourned until Thursday, February 17th at 10 a.m.
10 a.m. without objection, so ordered. Stay safe, everyone.